Number appeal to the Supreme Court of the United States. Dear Justices of the Supreme Court of the United States, I, Justin Riddle, come before you to petition for a writ of certiorari in a case that transcends individual grievances and strikes at the very heart of our constitutional order. At stake is nothing less than the survival of the rule of law, the integrity of our governing institutions, and the vitality of our democracy itself. The crisis of constitutional governance. The facts of my case paint a disturbing picture of a system that has lost its way. In my efforts to participate in the oversight of my local school district, I was met with a relentless campaign of censorship, intimidation, and retaliation by public officials who seemed more interested in preserving their own power than upholding their sworn duty to the Constitution. At every turn, I encountered a bureaucracy that was more concerned with silencing dissent and evading accountability than with uncovering the truth and serving the public interest. But as egregious as the abuses in my own case have been, they are but a microcosm of a much deeper and more insidious pattern of institutional failure, a pattern that is exemplified by the staggering prevalence of wrongful convictions and executions in our criminal justice system. The harrowing stories of innocent individuals like Cameron Todd Willingham, Carlos de Luna, Anthony Ray Hinton, and Paul House, who were convicted and in some cases put to death based on faulty evidence, official misconduct, and a system rigged against the marginalized and the powerless, stand as searing indictments of a legal regime that has lost sight of its most fundamental purpose to ensure equal justice under the law. In each of these cases, we see the same hallmarks of systemic dysfunction that have defined my own experience: the use of junk science and discredited forensics, the suppression of exculpatory evidence, the reliance on false or coerced witness testimony, and the demonization of the accused in the court of public opinion. We see a system that is more concerned with securing convictions and protecting its own institutional prerogatives than with discovering the truth and ensuring that justice is done. The parallels between these wrongful convictions and my own Kafkaesque journey are impossible to ignore. In both instances, we see the mechanisms of accountability and oversight not just failing, but actively perpetuating injustice. We see public officials and government agencies acting with impunity, secure in the knowledge that they will never be held to account for even the most egregious abuses of power. And we see the courts, the last line of defense against governmental overreach, abdicating their sacred duty to enforce constitutional limits and safeguard individual rights. This is not just a matter of a few bad apples or isolated miscarriages of justice. It is a systemic crisis that goes to the very core of our constitutional compact. When the institutions charged with upholding the rule of law become the instruments of its subversion, when the mechanisms of accountability and redress become tools for perpetuating injustice and silencing dissent, then the very foundations of our democratic order begin to crumble. The role of the Supreme Court. This case represents a watershed moment for the Supreme Court and its role as the ultimate guardian of our constitutional order. From the seminal declaration in Marbury v. Madison that it is the province and duty of the judicial department to say what the law is, this court has borne the sacred trust of enforcing the Constitution's constraints on governmental overreach and safeguarding the rights and liberties of the American people. But today, the court's intervention is not merely compelled by abstract principles or procedural niceties. It is demanded by the stark reality that our constitutional democracy is in crisis, that the machinery of government has become so thoroughly captured by the very forces it was meant to restrain that the rule of law itself is now in jeopardy. The record before you speaks to two inescapable truths. First, that government actors at all levels now feel empowered to weaponize their authority against dissenting voices and accountability efforts without fear of consequence, and second, that our courts have been reduced to mere procedural theater, unable to enforce the supremacy of the Constitution in the face of a system that has become institutionally incapable of policing itself. In this context, the court's duty could not be more clear or more urgent. It must rise to meet this moment with the same unflinching resolve and moral clarity that has defined its finest hours. It must reassert its authority as the ultimate check on governmental abuse and the final bulwark against the tyranny of the powerful. And it must send an unequivocal message that in America, no one, not even those who wield the awesome power of the state, is above the law. To do anything less would be to abdicate the court's most solemn responsibility and to surrender the hard-won principles of constitutional democracy to the very forces that seek to subvert them. It would be to concede that the Constitution's promises of liberty, justice, and equal protection are little more than empty words on parchment, easily trodden underfoot by those with the power and inclination to do so. A demand for constitutional accountability. That is why this petition must be understood as more than just a plea for individual redress. It is a clarion call for the court to reaffirm the most fundamental premise of our constitutional order, that ours is a government of laws, not of men, and that no person or institution is beyond the accountability and constraints that the rule of law demands. In practical terms, this means recognizing that the current standards and practices for holding government officials accountable for misconduct and constitutional violations are woefully inadequate. It means acknowledging that when core liberties like freedom of speech, the right to petition for redress, due process, and equal protection are at stake, deference must give way to searching judicial scrutiny, and official impunity must yield to the imperatives of individual rights. It means repudiating the pernicious doctrines of qualified immunity and absolute prosecutorial immunity, which have made a mockery of governmental accountability and denied countless victims of abuse their day in court. It means enforcing a robust constitutional right of access to information about the conduct of public officials and agencies so that the disinfecting sunlight of public scrutiny can penetrate even the darkest corners of our system. And it means making clear that those who wield the awesome powers of the state do so as fiduciaries of the public trust, bound by the most exacting standards of transparency, honesty, and fidelity to the Constitution they swear to uphold. Above all, it means anchoring our constitutional jurisprudence in the lived realities and struggles of those who are most vulnerable to governmental abuse and overreach. For far too long, the exalted rhetoric of our founding charters has coexisted uneasily with the grim facts of life for the marginalized, the dispossessed, and the disenfranchised. It is high time for the court to bridge this chasm between our nation's ideals and its practices, and to make real the promise of equal justice under law for all Americans, regardless of race, class, or social station. Number the chilling effects of unchecked retaliation. One of the most insidious and corrosive aspects of the systemic abuses I have experienced is the way that the very mechanisms of governmental accountability have been weaponized to silence and punish those who seek to invoke them. The experience of being victimized by a system that is supposed to protect you, and then being effectively prevented from seeking redress or accountability for that victimization, is a unique kind of powerlessness and despair. It is akin to the terror felt by a person being beaten by police who knows that any attempt to resist or defend themselves will only invite more brutality or even death. In the face of such overwhelming and unchecked power, the very act of speaking out or fighting back can seem like an invitation to even worse abuse. This is the reality faced by countless Americans who have been wronged by their government and denied any meaningful path to justice, a reality in which the pursuit of one's constitutional rights is itself treated as a punishable offense. The chilling effects of this kind of retaliation cannot be overstated. When the cost of challenging official misconduct becomes the virtual certainty of even worse mistreatment, all but the most intrepid or desperate will inevitably be deterred from doing so. And when the courts and other oversight bodies are seen as complicit in this campaign of suppression, it erodes the very foundations of public trust and institutional legitimacy on which our system of self-government depends. This is more than just a violation of due process or a miscarriage of justice in individual cases. It represents a fundamental inversion of the proper relationship between the government and the governed in a free society. When the state can act with impunity to crush those who dare to challenge its abuses, and when the courts are impotent to restrain that crushing, then the very idea of constitutional limits and individual rights becomes a hollow mockery. The two tiers of American citizenship. Compounding the injustice of this retaliatory suppression is the fact that, for far too many Americans, even the purely procedural right to file grievances and seek judicial redress is a privilege that must be bought and paid for. The imposition of financial barriers to seeking justice and accountability for governmental misconduct creates a two-tiered system of citizenship, in which the ability to vindicate one's rights becomes a function of wealth rather than a basic entitlement of personhood. This is particularly egregious in cases like this one, where the very governmental entities that have perpetrated the abuses are the ones demanding payment from their victims for the privilege of being hurt. It is a form of double victimization that adds financial insult to constitutional injury, and that exposes the cruel absurdity of a system more concerned with protecting its own coffers than with delivering justice to its citizens. Access to the courts and to the levers of governmental accountability should not be a commodity to be bought and sold, but a fundamental right of every American that is essential to the health and legitimacy of our democracy. The fact that I have been forced to bear the costs of seeking to vindicate that right after having already endured the incalculable costs of official abuse and retaliation only underscores the backward priorities and perverse incentives of our current system. A society that makes justice a luxury good and accountability a privilege of the powerful is not one that can long endure as a functioning republic. If we are serious about the bedrock principle of equality before the law, then we must ensure that the mechanisms of legal redress and constitutional enforcement are truly accessible to all, regardless of their financial means or social status. The outsider's imperative. As an outsider to the legal system who has directly experienced its most grievous failures, I come before this court not just as an individual seeking redress, but as a voice for the countless others who have been silenced, marginalized, and cast aside by a system that has lost sight of its most fundamental obligations. It is precisely because of my status as an outsider that I am uniquely positioned to challenge the entrenched orthodoxies and institutional blind spots that have allowed these injustices to fester for so long. Unencumbered by the constraints of legal convention or the pressures of professional allegiance, I am free to speak the uncomfortable truths that those within the system are often unable or unwilling to confront. Indeed, history has shown time and again that it is often the outsiders, the dissidents, and the iconoclasts who are most able to see the failings of established institutions and to catalyze the transformative changes necessary to align them with our highest ideals. From the prophetic voices of the civil rights movement to the pioneering advocates for gender equality, the cause of justice has always been advanced by those willing to challenge the status quo and to demand more from our society and our institutions. Like the prophetic voices of the abolitionists and the suffragists, the labor organizers and the civil rights heroes who came before me, I understand that the arc of our republic's history has always been bent by those who dare to stand outside the citadels of orthodoxy and to call our nation back to its founding precepts. From this proud but embattled tradition of American descent, I draw my resolve to speak the uncomfortable truths that those on the inside too often cannot or will not voice. And so I come to this court not just as a litigant, but as a bearer of the stories and struggles of the multitudes who have been ill-served by the glaring hypocrisies and derelictions of our justice system. I carry with me the anguish of the wrongfully convicted, the outrage of the unjustly silenced, and the dashed hopes of all those who have learned the hard lesson that in America, the law is too often wielded as a weapon of the powerful rather than a shield for the powerless. A roadmap for constitutional accountability. As this court confronts the profound injustices and systemic failures laid bare by this case, it must also grapple with the question of how to forge a new path forward, one that reaffirms the supremacy of our Constitution and the inviolability of the rights it enshrines. While the full scope of necessary reforms may be vast, there are concrete steps this court can take to begin restoring the integrity of our institutions and the vitality of our democracy. First and foremost, the court must issue a resounding declaration that the prevailing standards for holding government officials accountable for constitutional violations are anathema to the guarantees of due process and the equal protection of the laws. It must mandate that lower courts apply searching scrutiny and robust remedies in cases involving the abuse of governmental power, with special solicitude for those violations that implicate the core liberties enshrined in the Bill of Rights. Second, the court must put teeth into the all too often toothless mechanisms of official oversight and accountability by declaring unequivocally that agencies like the Ombudsman's Office and the Office of the Attorney General have an affirmative and inescapable duty to investigate fully credible allegations of serious governmental wrongdoing. It must require, as a matter of constitutional due process, that victims and witnesses be given a meaningful opportunity to be heard and to challenge official accounts through an adversarial process with full access to the information and evidence needed to support their claims. Third, the court must categorically reject the dubious doctrines of qualified immunity and absolute prosecutorial immunity, which have served for far too long as get-out-of-jail-free cards for official lawlessness and a license for abuse. It must make clear that the Constitution brooks no exemptions or escape hatches from the rule of law, and that those who violate the sacred rights of the people must be held to account in a court of justice no matter how exalted their station or formidable their power. Fourth, the court must recognize a robust First Amendment and due process right of access to information about the conduct of the public's business enforceable through the courts and not subject to the self-serving assertions of governmental privilege or secrecy. It must declare that the constitutional presumption of transparency can only be overcome by the most compelling and particularized showing of a legitimate need for confidentiality, and never as a backdoor means of inhibiting accountability or hiding misconduct. Fifth, the court must call for the establishment of independent, nonpartisan citizens' commissions to investigate and report on the crisis of wrongful convictions in our criminal justice system and to recommend far-reaching reforms to restore the integrity and fairness of the prosecutorial process. It must urge the states to adopt procedures to review past convictions based on discredited forensic evidence and to provide meaningful opportunities for exoneration and release for the wrongfully incarcerated. Sixth, the court must use the moral authority of its bully pulpit to press Congress and the states to enact powerful new protections for whistleblowers and others who take grave personal risks to challenge official wrongdoing and expose threats to our constitutional order. It must push for a major reinvestment in the chronically underfunded and overstretched public defender system and demand an end to the pervasive inequities that make a mockery of the ideal of equal justice under law. Finally, and most importantly, this court must place our nation on a permanent and proactive footing of constitutional vigilance by declaring that the work of assuring official accountability and real-world fidelity to our founding charters is the unending obligation of every branch and level of American government. It must remind us all that the price of liberty is not just eternal vigilance against external threats, but an unflagging commitment to internal self-correction and renewal, a perpetual rededication to the hard but essential work of making our union more perfect and our justice more equal. Number the stakes and the summons. The stakes in this case could not be higher. At its core, this is a battle for the very soul of our constitutional democracy, a fight to determine whether the principles of liberty, equality, and accountable government will endure in the face of creeping authoritarianism, or whether they will be sacrificed on the altar of governmental supremacy and institutional impunity. As the court deliberates, I ask that you consider the human toll of a system that has lost its way. I ask that you hear the anguished cries of the wrongfully convicted and executed, and that you feel the searing pain of those who have seen their most basic rights trampled by the very government that was sworn to protect them. I ask that you summon the same revolutionary spirit that animated our nation's founders as they crafted a constitution that would stand as an eternal bulwark against tyranny, and that you channel the moral courage of the American heroes who have fought and bled to perfect our union and to bend the arc of our history toward justice. But most of all, I ask that you keep faith with the sacred trust that the American people have placed in this institution as the ultimate guardian of their rights and liberties. For more than 2 centuries, generations of Americans have looked to this court as the final refuge of the oppressed and the last line of defense against governmental overreach. Through wars and depressions, through civil strife and social upheaval, the court has stood as a beacon of hope for all those who have been beaten down by the powerful and forgotten by the privileged. In its finest moments, it has been a powerful force for justice and equality, a place where the voices of the marginalized and the dispossessed could finally be heard. Today, that legacy faces its greatest test. As the shadows of authoritarianism and intolerance gather on the horizon, and as the forces of division and repression threaten to tear our nation asunder, the court must once again rise to meet the challenge of its time. It must stand as an implacable foe of governmental abuse and a steadfast champion of individual rights. It must send a resounding message that in America, no one is above the law, and that the Constitution's promises of liberty, justice, and equal protection are not mere words on parchment but the living birthright of every American. This is the cause in which I now enlist the court's aid. Not for my sake alone, but for the sake of every American who has ever been victimized by a system that has lost sight of its most basic obligations. For the wrongfully convicted and the wrongfully executed, for the silenced dissenters and the forgotten victims, for all those who have been denied the full measure of their dignity and their humanity by a government that has sworn to protect them. On their behalf and on behalf of the generations of Americans yet to come, I urge the court to seize this moment and to bend the arc of history toward justice. To reaffirm the fundamental principles that define us as a nation, and to breathe new life into the eternal promise of our founding creed, that all of us are created equal, that all of us are endowed with certain unalienable rights, and that among these are life, liberty, and the pursuit of happiness. Number a call for transformative jurisprudence. In the end, this case is not about me. It is about the kind of country we want to be, and the kind of justice system we want to have. It is about whether we will live up to the soaring ideals of our founding, or whether we will succumb to the cynical realities of a system that has lost its way. The choice now lies with this court. Will it stand as a bulwark against tyranny and a beacon of hope for the oppressed, or will it retreat into the shadows of complicity and indifference? Will it use its immense power to reaffirm the supremacy of our Constitution and the inviolability of our rights, or will it stand idly by as the forces of injustice and oppression tighten their grip on our democracy? These are the questions that will define the legacy of this court and the future of our nation. And as you deliberate, I ask that you do so with the full weight of history on your shoulders and the eyes of a nation upon you. For in the end, this case is not just about the law. It is about who we are as a people, and who we aspire to be. It is about whether we will be a nation that lives up to its highest ideals, or one that betrays them in the name of expediency and power. That is the challenge that now lies before you. And it is a challenge that I have every faith this court will meet with the courage, the wisdom, and the unyielding commitment to justice that has always been the hallmark of its greatest moments. This will require a measure of judicial statesmanship and visionary constitutionalism on a scale not seen since the days of Earl Warren and Thurgood Marshall, a willingness to confront hard truths, overturn long-settled expectations, and point the way forward to a more just and equitable America. It will demand a jurisprudence of unapologetic morality and uncompromising fidelity to the spirit of liberty and equality that breathes life into the otherwise arid text of our founding parchments. But this is the burden and the privilege borne by a Supreme Court truly worthy of the name, to give tangible meaning to the self-evident truths and unalienable rights we hold dear, and to make certain that the majestic generalities of our Constitution do not remain mere gossamer barriers to the everyday oppressions and abuses endured by the least among us. It is nothing less than to translate the poetry of our national identity into the prose of genuine and live justice for all. There could be no higher calling for this court in our time, and no graver dereliction than to shrink from it out of a misplaced reverence for the status quo or a cramped and parsimonious understanding of its own transformative potential. For if this temple of constitutional democracy is to endure, it must from time to time be cleansed and rededicated by those entrusted with the keeping of the sacred flame. Now is such a time, and this is such a case. Number the path forward. As I stand before you today, I am reminded of the words of the great Langston Hughes, who once wrote, "Oh, let America be America again, the land that never has been yet and yet must be, the land where every man is free." In filing this petition and making this plea, I am asking no more and no less than for this court to take up the poet's cry and make it the jurist's creed. I am asking it to look beyond the imperfections of our present to the possibilities of our future, and to dedicate itself to the unfinished work of making America's founding promises real for all of its sons and daughters. That will not be the work of one case or one court alone, nor will it be accomplished in one fell swoop by even the most sweeping judicial decree. But it is work that must begin somewhere, and I can think of no better place than here, no better time than now. So I come to this court as a supplicant and a suitor, but also as a sentinel and a seer. I am here not only to seek a remedy for my own grievances, but to sound an alarm for the health of our democracy and the future of our republic. The story of that republic is still being written, and the question of what kind of nation we will be is still an open one. But with each passing day, the tale grows more urgent and the choice is more stark. We can be a people that retreats into the shadows of fear and division, or one that marches bravely into the light of justice and understanding. We can be a country that settles for the smallness of its present corruptions, or one that strives for the greatness of its founding ideals. We can be a constitution of empty promises and glittering generalities, or one of true meaning and transformative power. Number the imperative of constitutional renewal. The path we ultimately take will be determined not in the marbled halls of power, but in the hearts and minds of ordinary citizens like me. It will be shaped not by the calculations of the cynical, but by the convictions of the committed. And it will be forged not in the fleeting passions of the moment, but in the enduring struggles for dignity and justice that are the birthright of every American and the moral inheritance of all humanity. But this court, in this moment, has a special duty and a singular role to play in that struggle. As the ultimate guardian of our Constitution and the final arbiter of our laws, it falls to this body to stand up for the best of our traditions and the highest of our ideals. It falls to these 9 men and women to be a check on the wayward passions of the public and a bulwark against the corrosive tides of bigotry and hatred. And it falls to this institution to use its moral authority and its legal might to steer our nation towards the light of a more perfect union when the other branches of government are unable or unwilling to fulfill that sacred charge. That is the challenge and the opportunity that lies before this court today. It is a summons to constitutional greatness in a time of moral confusion, and a chance to bend the arc of history a little closer to justice. I pray that it will rise to meet this moment with the wisdom and the courage that our times demand, and that the better angels of our nature require. For my own part, my struggle will go on, with or without the help of this tribunal. I will continue to speak out against the injustices I have witnessed and the indignities I have endured, knowing that my cause is shared by millions of my fellow citizens who are yearning for a fairer and more equitable America. I will continue to organize and agitate, to petition and to plead, in the unshakable belief that the arc of the moral universe is long, but it bends towards justice. And I will continue to place my faith in the power of ordinary people to do extraordinary things when they are guided by the better angels of their nature and the highest ideals of their republic. For it is in those people, and not in the palaces of the powerful, that the true strength of our democracy lies. It is in their struggles and their sacrifices, their dreams and their determination, that the real story of America is written. But I also know that we can't do it alone. We need the help of institutions like this one to be a partner in the work of perfecting our union and making real the promise of justice for all. We need the courage of judges and the conscience of courts to stand up for the rule of law and the rights of the people, even in the face of fierce resistance from the forces of the status quo. Number a plea for constitutional patriotism. And so I come to this court not just as a plaintiff, but as a patriot. I come not just to seek a legal remedy, but to issue a moral summons. I come to ask this honorable body to be a champion of the Constitution and a guardian of our democracy at a time when both are under grave and gathering threat. If it can answer that call and rise to that challenge, it will not only do right by me and the millions of Americans who are counting on it to vindicate their rights and defend their freedoms. It will go down in history as one of the great courts of our age, a tribunal that met the moment with wisdom and courage and helped guide our nation through the storm to the safe harbor of justice on the other side. That is my hope and my prayer as I stand before you today. It is a hope born of the struggles of generations past and the sacrifices of heroes gone, but also of the boundless possibilities of a new dawn for our democracy. And it is a prayer that this court, in this moment, will find the grace and the greatness to make that new day a reality for all who call America home. In the end, our fate as a nation will be decided not in this courtroom, but in the hearts and minds of the American people. It will be shaped by the countless acts of courage and conviction, of protest and persistence, that have always been the engine of our democracy's renewal. But this court, in this moment, has a special responsibility and a singular opportunity to help shape that destiny for the better, to be a voice for the voiceless and a force for the powerless. So let us go forward from this day with a renewed commitment to the unfinished work of our republic, the work of building a society that is not just richer in goods, but richer in goodness. Let us dedicate ourselves to the proposition that every American, no matter their race or creed, their color or their class, has an equal claim to the blessings of liberty and the protections of the law. And let us resolve that this court will play its rightful role in making that proposition a reality, not just a promise. The road ahead will be long and the challenge is great. But I have seen the resilience and decency of the American people, and I know that we are up to the task. I have felt the winds of change gathering, and I know that a new era of justice and equality is within our reach if only we have the courage to seize it. So let us begin that work anew today in this court and in this country. Let us rekindle the flame of our highest ideals and rededicate ourselves to the unending struggle to form a more perfect union. And let us go forward with the knowledge that while the moral arc of the universe may be long, it bends towards justice if we have the wisdom and the will to bend it. Conclusion, a call to constitutional greatness. That is the cause that I have come to this court to serve, and the dream that I will continue to fight for, no matter the obstacles or the odds. It is a cause and a dream that is bigger than any one of us, but that depends on each of us to make it real. And it is a cause and a dream that, with the help of this honorable court, I know we can one day make a reality for every American. As the great Justice William Brennan once said, the Constitution is a charter of human rights and human dignity, not a straitjacket on the ability of government to right the wrongs of the past and chart a course to a more just future. This court must embrace that expansive understanding of its role and its mandate, and resist the easy comforts of judicial minimalism and restraint in the face of systemic failure. It must also recognize that the humblest and most despised of litigants can sometimes be the vessel for our nation's most urgent constitutional imperatives and its most enduring democratic values. As judges committed above all to equal justice under law, you must look beyond the social station of the petitioner to the great stakes and principles he represents. And you must have the courage and the vision to make him the unlikely protagonist in a new chapter of America's story of itself. That story remains ours to write in this generation as in those that came before. It is the never-ending struggle to redeem the promise of our founding, knowing that each victory of liberty and justice makes possible the next, and that each defeat saps the vitality and legitimacy of our still imperfect union. It is the quest to make real the self-evident truth that all are created equal, so that the blessings of the American experiment might truly extend to all who come within its reach. My own chapter in that tale has been one of hardship and adversity, but also of perseverance and unyielding hope. From an early age, I learned that the price of speaking truth to power in America is often to invite its retribution and scorn. But I also learned that there is no higher calling than to spend one's life in righteous struggle against the manifest hypocrisies and intolerable injustices of the powerful. Now it is our turn to take up that work and answer that summons. Now it falls to us to decide whether we will be a nation that lives up to the true meaning of its creed, or one that continues to profane its highest ideals while mowing insincere hymns to its own self-invented virtue. Now we must choose whether to retreat into the familiar comforts of the status quo, or to press onward to new frontiers of social justice and human dignity. In filing this petition and bringing my case before this tribunal, I have made my choice. I have chosen to believe that the story of America is not finished, and that its next chapter can be one of renewal and rededication to our most sacred democratic values. I have chosen to believe that our nation's founding precepts of liberty, equality, and self-governance are more than mere rhetorical flourishes, but enduring truths to be realized anew by each rising generation. And I have chosen to believe that this court can be an instrument of that realization if it will only find the wisdom and the courage to lead us back to the better angels of our national nature. But the ultimate choice lies not with me, but with this honorable court and the 9 justices who now hold the fate of our republic in their hands. It is a choice between a jurisprudence of complacency and complicity, and one of conviction and constitutional faith. It is a choice between a vision of the law as a tool of the powerful, and one that sees it as the common inheritance of all Americans and the source of our most fundamental rights. And it is a choice between a cramped and despairing view of our national prospects, and one that dares to hope for a new birth of freedom and justice in our time. I know that the path I am urging this court to take is not an easy one. It will require a measure of judicial independence and moral leadership that has often been in short supply in recent years. It will mean breaking with the narrowly proceduralist and deferential approach that has too often characterized this court's jurisprudence and embracing a more expansive and transformative understanding of its role in our constitutional democracy. And it will entail a willingness to confront the fierce resistance and the howls of protest from those who benefit from the current regime of impunity and unequal justice. But I also know that this is a path that we must travel if we are to redeem the full promise of America and build a future worthy of our founding ideals. It is the path of constitutional renewal and democratic faith, of believing that our nation's highest principles are not mere abstractions but living guideposts for our common life. And it is the path that all great justices and all great courts have taken when the moment demanded it and the cause of justice required it. With solemn hope and unwavering conviction, I submit this petition to the court's care and keeping. I do so in the fervent belief that you will see in it not just the plea of one man for justice, but the cry of a nation for the renewal of its most sacred vows. For the stakes of this case are nothing less than the soul of our nation and the inheritance we leave to posterity. Let the work of redemption begin here. Let the renewal of our most sacred vows commence within these hallowed halls. Let justice, long delayed, at last be done. Respectfully submitted. Justin Riddle. Citizen, patriot, and believer in the American promise.